All right, so we've got everyone here on 23268, and there has not been an order issued, but we're considering that today. And the court, finally, we've got service on Ms. Hall, so she's been made aware. So Ms. Hall, I see that on October 2nd, you were given notice of the hearing. And so Ms. Weaver, on behalf of your client, are you still seeking this order against Ms. Hall?
Yes, Your Honor.
All right. And Ms. Hall, do you have an objection to this order issuing against you?
No.
I do.
Ms. Hall?
I do.
That's who I'm talking to. All right. Okay, so, and you'll notice I'm looking to my right, because I'm looking at the court file electronically and all the information that's been filed there. What I have are the petitioner's exhibits. And then Ms. Hall, I didn't see that you filed anything for me to review before today's hearing. Is there anything that you wanted the court to review? Any documents?
There are no documents because
okay. I'm going to hear from everyone, but I just want to be sure I'm not supposed to be looking at any documents before we start. Okay.
Thank you.
All right. And so, Ms. Weaver, you're prepared to go forward on this case today?
Correct, Your Honor.
All right. And Ms. Hall, are you prepared to go forward on this?
Yes, Your Honor.
Okay. All right. So I've had an opportunity to review all that's been filed by the petitioner and all that's in the court file. And Ms. Weaver, is there anything else or something you wanted to highlight? Anything on behalf of your client that you wanted the court to consider?
Yes, Your Honor. Just briefly, if we may have Ms. Bird sworn in.
All right. Ms. Weaver, go ahead.
All right. Ms. Bird, was everything that you wrote in the petition true and correct?
Yes.
And then in the petition, it mentions your mom, Ms. Hall, contacting you via text. Has she contacted you via text or otherwise since that initial petition was filed?
No.
Okay, I'll rephrase. That was kind of a confusing question. Did she contact you in January of 2023?
Oh, yes.
How did she contact you?
Through WhatsApp.
And in that WhatsApp message, did Ms. Hall acknowledge that she was aware that you did not want to be contacted?
Yes.
And what was she trying to do? What was the purpose of her communication?
Based off of the text message, it was basically she didn't want to spend any more days separated from me and my son, and that just that she was leaving outside of the country and just giving me information on things that she was currently doing in her life. And yeah.
Did she mention anything specific about your grandson and a bank account?
Yeah, she said that she was setting up an account for him so that when he turns 21, he'll have something from her. And since she couldn't send any gifts, she thought she could at least leave him something.
And then, Ms. Bird, when this petition was initially filed, you had an infant child. Are you currently expecting a child, a second child?
Yes.
Okay. And does everything apply in terms of what you were saying in the initial petition about the need to have low anxiety and situations that are not stressful for you?
Correct.
And that's based on the pregnancy, based in part on the pregnancy?
Yes.
And Your Honor, I have no further questions for Ms. Bird.
So let me ask, there have been two other petitions filed, and one was the 2323 that was dismissed March 20th when no one appeared. Ms. Weaver, I don't know if you can answer what happened there.
Your Honor, I was in the emergency room with a concussion.
Okay.
And so my other two colleagues were in the middle of a double homicide trial. And unfortunately, due to my hospitalization, that was our fault that somebody did not appear on that.
And Ms. Bird, why did you not appear on March 20th when we had that hearing?
Because our lawyer was indisposed, we weren't contacted privy to the court hearing.
All right. And then Ms. Weaver, July 10th, the same thing happened. Why didn't anyone appear from petitioner? I don't know if you were representing her then, actually.
I'd have to go back and look at July 10th. I'm not sure, because aside from that one hospitalization, I don't recall ever.
Okay. So Ms. Bird, why didn't you come to court on July 10th when you renewed this petition and asked the court to hear things?
And Your Honor, I can say this, our office, we contact our clients and let them know when hearings are. And so if that didn't take place, then that would be the reason.
Okay, and the court also gives notice at that last hearing. She wasn't present June 26th, we reset it, wasn't present June 12th, we reset it, wasn't present May 30th, we reset it, May 19th, you were before the court, the temporary order was granted. So, and we reset. So your understanding is your client didn't come because a failure in your office?
No, Your Honor. Many of those, and I would have to specifically go back and look at the docket. I would say 90+% of those continuances were due to having trouble serving the respondent. I'm
just worried about this July 10th one as to why there wasn't anyone here to follow up on the second request for an order, and then now we're on the third. I'm glad everyone's appeared, but
and I am recalling that now, Your Honor. I was told by at the previous hearing that if we were unable to effectuate service, that there were going to be no further continuances. We weren't able to effectuate it, and assumed that would take place. And the reason why we refiled again was when we received a letter from Ms. Hall's attorney pertaining to a different matter. And so we then had an avenue of contact that we knew we could locate Ms. Hall.
And then if you could, Ms. Weaver, help the court understand, pursuant to the law, there are certain things I have to find here. Under unlawful harassment, can you substantiate those components? Maybe give me a summation and then I'll turn to Ms. Hall so she knows what she's responding to.
Yes, Your Honor, I'd be happy to do that. So as the court knows, the unlawful harassment requires several things to be found by the court. First would be a knowing and willful course of conduct. And the course of conduct here is the multiple contacts by Ms. Hall after several requests by Ms. Bird that she not contact her. So it was despite Ms. Bird saying, "I do not wish to have any additional contact with you. Please stop contacting me." And the continued contact in the face of her requests. So it was the November 1st, December 5th, and then again in January of 2023. So that is the knowing and willful course of conduct. And it's notable that in those communications, and I believe there was also an email on August 12th. In those communications, at least twice, Ms. Hill acknowledges that there has been a request for no contact, or that she not reach out to Ms. Bird. So she says, "I know you don't want to hear from me," and continues to contact her. And so after a very clear request for no contact, continuing to do so, at least 4 times, is a knowing and willful course of conduct. It's also directed at a specific person here. That specific person is Ms. Bird. And the third factor is that this course of conduct alarms, annoys, harasses, or is detrimental to such a person. And here I can understand, well, not it would appear from an outsider looking in and simply just looking at the words that maybe Miss Hall is, coming from the kindness of her heart and is trying to be an active grandparent. However, as Miss Bird explains in her petition, she knows after a lifetime of being raised by Miss Hall and having been exposed to and familiar with Miss Hall's type of communication, and what that communication actually is conveying is not necessarily the words that are coming out of her mouth or being conveyed. There are tones of guilting. There's a lot of guilting and shaming. So for example, in the text message from January, she talks about how, I don't have much time on this earth. And that's kind of a Miss Bird, that's guilting Miss Bird into saying, oh, I should be reaching out because, my mom's going to die. She's basically, I'm going to die soon. So that is a kind of manipulative thing to bring up to try to get her daughter to talk to her. So again, despite the request for communication sounding innocent and not meant to annoy or harass, it is the type of harassing or guilting, shaming communication that Miss Bird is familiar with from her childhood and from throughout her life. And then the court would also need to find that there was no legitimate or lawful purpose. There is not a legitimate or lawful purpose for Miss Hall to continue contacting Miss Bird despite her wishes that she would not. Grandparents do not have any legal right to grandchildren, to seeing them, to supporting them. So if Miss Bird says no, Miss Hall needs to respect that and discontinue contact, even if she thinks that she's doing the right thing. Miss Bird has indicated that she did not want to. It causes her stress and anxiety, but she continued to do it. Another factor that the judge would need, Your Honor, would need to find is that a reasonable person would suffer emotional distress in a similar situation. So a reasonable person in Miss Bird's position, so that is with a new infant and then also being 7 months pregnant, a mother in that position is going to feel substantial emotional distress by a person continuing to contact them when they do not want to be contacted, when they're feeling shamed and guilted and just constantly made to feel like she's a bad daughter and that she did the wrong thing by marrying her husband and that they don't approve. That would cause a person in her position to feel severe anxiety. Every time you open your email, every time you pick up your phone for a text, being worried about reading something that will put you into a state of high anxiety and distress. I think a reasonable person in her position would. And finally, the court would need to find that this course of conduct actually caused substantial emotional distress. And Miss Bird describes that in her petition, and it's also might not be specifically described in the journal article, but I think the journal article is helpful in allowing the parties to understand and get an idea of the importance of having a non-stressful environment for both a child who has already been born and a child who is developing in the body. So the emotional distress that she feels, she describes in her petition, and she describes it that it takes several days sometimes for her to come down from this state of anxiety and state of essentially worry, for lack of a better word. Her parents Miss Bird's parents had a significant impact on her life, and she essentially was able to kind of break free from a household where she was being frequently guilted and shamed, broke free of that. And so anytime that she receives communication from that kind of past place that she worked hard to distance herself from, it takes a while for her to bring herself down from that again.
So can you tell me your client's taken when she decided she didn't want to have any communication from Ms. Hall? What steps did she take to cut that off?
Your Honor, she conveyed that to her, I believe, via text and via email. And
right, so I'm looking at the May 31st of 2022, September 29th of 2022 screenshots of communication, and it's a little difficult to figure out who's saying what, but one of them, the September 29th, says, "I will be blocking, no need to respond." I don't know who said that or what that. You can help me understand that.
The blue bubbles
it's not in blue, unfortunately. Mine's black and white.
Oh, I see. So those are text messages that Miss Bird directed that were sent to Miss Hall. So you can see Mama Bear is there at the top of the text message. So that's the person the text is being sent to.
So Mama Bear is Ms. Hall?
Correct.
Okay, and then so all of this that's been screenshotted and provided to the court as an exhibit on September 29th is all of your client's writing?
Yes.
Okay, and that was September. So she was texting her mother, and then our last conversation letting you know that until Dad apologizes with sincerity, there will be no communication. Let's see, so continued on for a very long text, and part of this, and then finally, your client's also saying, "I will be blocking, no need to respond." Is that her statements?
Correct.
And yet, until there's a sincere apology, how, so that's inviting contact, it seems to me, that there is an opening. So if you can help me understand this and later information that you filed with the court, if there is any, help me understand how there isn't, that it's pretty clear, no contact. When there's this conditional, until you apologize, then we can have communication.
Right. And so I think clearly they can communicate, because there have been future communications or communications after that by other means. So there was the WhatsApp, I think, communication, and then also via email.
And that was after September of 2022? I just don't have any of that before the court.
Sorry, I apologize, Your Honor. The court, I believe, was asking, my understanding of the court's question was if there was an invitation essentially to say, "I'll talk to you if you apologize." How are they supposed to do that if she's blocked? And I was explaining that they did have the ability to do that with an apology. But none of the future communications were an apology. It was just kind of like the guilting, shaming,
So none of that was that in other petitions that you filed those, but in this order, there's nothing else filed about that. Is there something else?
Nothing else filed about what?
About what you're saying after what I have is May 31st, that text message, September 29th, which you told me is all of your client texting to her mom saying, "I will be blocking, no need to respond," after this kind of conditional blocking. But is there something after that wasn't filed with the court to support this petition?
Your Honor, does the court have attachment A?
I have attachment B and attachment A. And attachment A are the text screenshots and something looks like an email from August 12th of 2022. And your client's statements with, I'm not, if these are texts, I think from happy holidays and I love you. I'm not.
Yeah. So
The
those
determined
were the
date. November
those were
1st, December 5th. Okay.
those were the ones I was referring to here. So
Okay. And Bree, who's Bree? Is that your client? Is Bree?
I believe that might be a nickname.
Okay. All right. I kind of guessed that. And then another to a beautiful daughter. I presume that's from Ms. Hall in December 5th. All right. And then, of course, these are intersposed in between your client's statement to the court. All right. Okay, so this, if you need anything, reach out. So, and it looks like from your client statement that there's a difference in spiritual belief that's part of this.
Yes. There was essentially they were not supportive or fully supportive of Miss Bird marrying her now husband, Mr. Bird. And they made that clear at the wedding with some kind of overt disrespectful behaviors, like not shaking hands after walking down the aisle. And so these have to be kind of read in the context of that and understanding that the manipulative behavior or the manipulation is continuous. It kind of permeates all of their communications, their interactions, and Miss Bird simply can't handle that now that she's a mother, and particularly not wanting to cause distress to her baby and to her family. As she wrote, it takes her several days to kind of come down again after receiving these contacts.
All right, let me turn to Ms. Hall unless there's something more, Ms. Weaver.
I'll reserve any additional argument for a response after Ms. Hall.
Okay. Well, we're just going to hear from you, and then I'm going to turn to Ms. Hall, and then I'm going to make the decision. So is there something more?
Simply because, Your Honor, I don't know what Ms. Hall is going to say because we didn't receive any documents from her. So I don't know what information she's going to share. And because of that, I simply would ask for an opportunity, if need be, to respond to something if she presents new information.
We'll see. All right, Ms. Hall, your side of why the court should not issue this order.
I don't feel that the order is necessary. I haven't contacted my daughter since January of this year. My intention was not to be manipulative, or my intention at any point in time was not to be manipulative or guilt or shaming in any capacity. My daughter and I had a very close relationship prior to May 30th of 2022, which was in Javon. My family was present. There was no situation that my husband or I was a part of. We left prior to that even occurring and did not return. We were fully supportive on that day. And I don't quite know where the non-handshaking occurred because that actually did happen. Where they might be referring to is when the officiant indicated that, is there anyone to give away my daughter? No one from the family stood. And there was a disagreement between my husband and Mr. Bird prior to that, based upon my husband not being in agreement of them getting married so soon because the relationship happened really quickly. There was no intention on our behalf to shame or guilt my daughter for choosing a different faith. She grew up primarily in a Christian home, in a Christian background, singing with her father and I, and our whole family was a part of that. But there was no intention of us not wanting to break our relationship with our daughter based upon her beliefs. And, you know, the day after the a wedding, we received a text message from Mr. Bird indicating that we were not to contact our daughter again. And we just thought it was strange that we would receive a communication from Mr. Bird. What he communicated to us was that after he married our daughter, that we would no longer have access to her. And so that's what.
Maybe you can tell me, all right, there have been these allegations that you've responded November, December, January, when your daughter thought that she told you, don't contact me.
Mm-hmm.
Do you want to talk to any of that or?
Yeah. So what had happened was I talked to my daughter around the 17th of September. This was out of the country for 2 weeks. I was on a cruise in Mexico and didn't have access to communication or anything. But in that conversation, my daughter indicated to me that she is open to having a relationship with me, and that she and I could have a relationship, but she had an issue, or Javon had an issue with the disagreement that she and her father had. And so I understood that and agreed to those, to be very respectful of that. And what I had indicated to my daughter was there isn't anything that I can do as an individual to force her father to apologize to her husband. That isn't within my power or my capacity. That would be something that her father would need to do on his own. And so that was my last communication verbally, where my daughter called me. And we talked for several hours. And then she told me right back, and she called me back 5 minutes later and, you know, continued the conversation. I then went into a choir rehearsal, and, you know, everything hadn't there. That's where I left it. That's where I understood it was left. And then
there's this text that's been filed, that from September 29th in the court file that we were talking about,
yeah.
And still saying that something I wish to express based on our last conversation, letting you know that until Dad apologizes to Jaden with sincerity, there will be no communication between me and you. So where did all that fit in?
Yeah. So the communication on September 29th, as I had mentioned, I was out of the country until October 4th. I didn't get back until October 4th. I never received that text message.
Okay. So then since October 4th, you know, there's this allegation of a November 1st contact and a December 5th in the court file. Just a note to let you and Shakeen are thought of and prayed for daily. There's nothing that will remove my love from you. And that you wrote that. It says, I think it's a text. It's a screenshot, November 1st. And then on December 5th, it's kind of the loved by your parents, miss you, deep desire to counsel, desire to know you and your baby will all be regarded and have a safe place as long as you and father draw a breath. Give love, saddened by the inability to connect and develop a relationship. Don't hesitate to reach out. We are here. So you wrote those to your daughter?
I did, and those were via email.
Okay, thank you. Not sure what that was. And then there's going way back in August 12th. So before the trip. All right. So you say you didn't receive the September 29th, and then you contact November 1st and 5th. So after that, November 1st, November 5th, did you get anything from your daughter saying, leave me alone? What did you get? Anything in
Mm-mm.
response?
Yes, Your Honor. There was no response.
So when, it's a no response, and then when was the next time that you did get any kind of response from your daughter?
That would have been when I got served on the March 20th.
Okay. First petition. All right. All right. And so so March 20th?
Yeah, I believe that's the first, let's see. So there was the first petition that I received. The hearing was held on March 20th at 9 a.m. And that's the one that I was served at my home. Actually, my husband was served, and that's the one that was filed January 25th, 2023. But I didn't receive it until like the day before, or that Friday before that Monday hearing.
Right. So you haven't had
So
any back and forth with your daughter since that December 5th. I think it's an email you said.
No.
Right. Anything else that I should consider?
Just that it's not my intention. I love my daughter. I respect her. I respect her family. I don't feel like the contact order is necessary because I have no intention of reaching out or contacting them in any capacity, nor do I plan to do that. They initiate first.
So is anything on those points?
I didn't hear you.
Ms. Hall, is there anything more?
No, Your Honor.
Okay, thanks. So Ms. Weaver, anything more?
Your Honor, nothing more than just to point out again the January 2023 communication where Ms. Hall reaches out to Ms. Bird and does acknowledge, saying, I know you don't want to hear from me, and then continues to contact her about the setting up a bank account for her, for the grandson.
Okay. All right. So Ms. Bird, Ms. Hall, I'm applying the law of RCW 1014. It used to be, I'm sorry, 7105 now. And so Ms. Bird and Ms. Weaver, I'm not issuing an order against Ms. Hall. I don't find that it really reaches the standard of unlawful harassment. Ms. Bird, you may not like it. You may feel it's disrespectful. You may feel all the things you're feeling, and we're not discounting that. But I have to find, was there unlawful harassment that a reasonable person would be subjected to substantial, not just, but suffer substantial emotional distress that would actually cause substantial emotional distress and seriously annoy, harass, or be detrimental. And certainly all of this has been instructive, I think, to Ms. Hall, and she said here that she understands that there's to be no contact with you, and she won't, I hope, going forward. But I'm not finding that what the law requires me to find, that you are not particularly physically or emotionally harmed by these, and that Ms. Hall had any intention of committing this substantial distress upon you. So there's not an order. Ms. Hall, I think, is pretty clear here from your petition here, from the exhibits you filed, from the statements from your attorney, that they're just don't want any contact from her. So I hope that she has listened hard to that. And from what we've heard from her, she believes this is not necessary because she won't contact you. But that's not what I'm basing this on. What I'm basing on is the law and not meeting those legal standards. So this ends today. There will be no order, and everyone can be on their way. So anything else, Ms. Weaver?
No, Your Honor.
And Ms. Hall, anything going forward?
No, Your Honor.
All right, then everyone can be on your way. I'm going to sign an order
Yes,
here
Your Honor.
that dismisses the
Speaking of
petition.
case
23310 is the request for an order against you, Mr. Carter, by Priscilla Hughes. And let's see, we put you both under oath. Ms. Hughes, if you could raise your right hand. Ms. Hughes, do you swear you'll tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, and Mr. Carter, if you raise your right hand, swear to tell the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
Okay, so Ms. Hughes, are you still seeking an order against Mr. Carter?
Yes, Your Honor.
All right, Mr. Carter. So Ms. Hughes, first, you feel you're ready for this hearing this morning? You prepared and reviewed everything?
Yes.
Okay. And I see Mr. Carter was served with this September 29th, and I'm looking to my right here as I'm looking at the court file. It's electronic, so I'm listening, but trying to get all the information up here. And Mr. Carter, you prepared to respond to this? You filed several exhibits. You're prepared to respond?
Yes, Your Honor.
Okay, all right. So, and I've had a chance to review everything here. Ms. Hughes, from your point of view, is there anything else that you haven't filed already or said in a statement? Anything you want to focus in on that you want the court to consider in your request?
There's nothing additional beyond what I have filed, with the exception of the fact that I was informed by Ryan's former roommate, who knows about the hearing, that Ryan has abandoned his apartment and his lease. And at this point, I have no idea where he's located or how to avoid coming into contact with him. I'm frankly nervous to be out in public and have paid to upgrade my outdoor security system and to have somebody house sit for me when I travel for work. I don't know how to avoid coming into contact with him because I don't know where he is.
Did he ever come to your house when you didn't want him there?
No, Your Honor, but he has mailed things to my house.
Right, the book that he borrowed, apparently. Maybe you can tell me, I mean, help me understand why that is a basis.
I do have some comments about his rebuttal. The book, I did give him the book. I did not express any expectation that that book be returned to me. I did not ask for the book to be returned to me. We've exchanged several small gifts throughout the duration of the time that we were friends. And I believe the book was mailed to me because it was the smallest and cheapest item that he could send, to express that he could still contact me despite my efforts to stop him from doing so.
Why do you think that?
Due to the public interactions that he attempted to stage between the two of us when he attempted to show up at my book club meeting, and the fact that he went out of his way to locate my pet sitter when only having the pet sitter's first name, and for some reason attempt to board his dog at the same time that my cat was there while I was traveling for work. I feel that that was just another attempt to intimidate me, due to the fact that his dog experiences pretty severe anxiety and aggression towards cats. And I believe that it was just an attempt to orchestrate a run-in when I was dropping off or picking up my cat. It didn't seem that there was any valid basis for his dog to be there at the same time.
And the book club, was that online or is that in person?
It's in person. And what occurred there is that he joined the Facebook group.
In person in someone's home or in person on Zoom, I guess, to be clear.
It's physically in person, and it's held at the Rainbow Center in Tacoma.
Okay.
And there is a Facebook group where the meeting information is posted.
Right. Okay, that's what I'm thinking. And so on Facebook, you asked that he be excluded from that book club, and then they excluded him and let him know that, apparently. All right. But it was an in-person event. So,
Yes, Your Honor.
Has he ever threatened you harm or threatened harm to your home? Or
Not verbally, but I do believe that it has been implied with some of his actions.
can you help me understand that? Where? What have you filed here that shows that?
The first and foremost, I've only known him for 4 or 5 months, and he has never exhibited any sort of behavior like this whatsoever. This all kind of came out of nowhere. And once again, about his dog exhibiting aggression towards cats. My pet sitter is primarily focused on boarding cats. I've pet sat Ryan's dog before and witnessed firsthand his aggression towards cats. And I do believe that him attempting, out of all of the other people he could have left his dog with, attempting to put the dog in the same space as a cat that he has exhibited aggression towards was a threat.
All right. So it's the book coming back, the book club, when he responded there, and the boarding of his dog at the place where you board your cat. Anything else?
Yes. I have read the comments that he submitted for rebuttal, and I see that his belief is for some reason that I have orchestrated all of this on behalf of his ex-girlfriend and in some kind of attempt to hurt his job, when he has submitted screenshots proving that he has done these things and that he's done them after I asked him to stop contacting me. I think he's completely unaware of how his behavior is affecting my day-to-day life and my personal safety. And due to the fact that the behavior stopped once he was served with the paperwork, I believe that it's clear that this anti-harassment order would work and that he's just going to pick up where he left off if it isn't granted.
Can you show me or direct me in your response to what Mr. Carter's filed here that gives you that that says you told him to stop contacting you and he violated that, or that he put you in fear of some harm? Can you help direct me through all of this? It's difficult for me to sometimes figure out who's saying what too, because one says Nathan Ducat Facebook, but it's not always clear who's saying what in these. And so if you could look through that and tell me, focus in on what it is that in this response that you're referring to that says.
Yes, Your Honor. So the Nathan Ducat is an admin from the book club. And I included this to show that I asked that he quietly be removed from the Facebook group without altercation. The admins agreed that he should be removed, as he had never previously interacted with the group, never attended a meeting, had no business being in the Facebook group when he did not attend the meetings.
Somewhere in here where all this says, help me understand who's saying what in here that
those are
this problem. So yeah, message 1, 2,
those
3,
are in his
4, 5.
screenshots, Your Honor.
Okay, and maybe they're message 1, 2, 3, 4, 5, anything through 10. Do you know who's saying what in these? Are you aware?
Colton, yes, Your Honor. What I'm referencing currently is screenshots that Ryan submitted between Colton and Nathan and himself. Or excuse me, I believe it was just Nathan.
All right. So you think this is between Nathan and Mr. Carter?
Yes, Your Honor.
Okay. So in looking through all the information that Mr. Carter filed, I guess your response, and if you can zero me in on anything in particular that makes you think what you're thinking.
Yes, Your Honor. Just that he claims that there's no basis for this, and I'm orchestrating this for some unfathomable reason, but he includes screenshots showing that he has reached out to the book club admins. Those are between Nathan and himself. These screenshots that are numbered message 1, 2, 3, and 4, it's attachment C in my documents, showing that he did find my pet sitter and state that we were friends and that he would like to board his dog with the pet sitter. And attachment B is just proving that he did mail the book package to my house. The screenshots with the pet sitter also, which were submitted by Ryan, show a date after I asked him to stop contacting me, although he states that this happened before I asked him to stop.
If I have any other questions here. And so the boarding was over Thanksgiving last year, or was there another boarding?
It's an upcoming boarding in November. Yes, Your Honor.
November, this is this year.
Yes, Your Honor.
Oh, okay. And so you made your arrangements when for this year? You made your arrangements when?
I made these I've been seeing Parker, the pet sitter, for over a year, and I made these arrangements sometime likely in June or July of this year.
All right. That helps me understand this better. And when did you discover any of that?
I discovered this when I apologize. Quite a few papers in front of me. On September 21st, I contacted Parker to confirm another travel date for later in December, and was asked at that time about an overlapping booking between Milo and his dog and my cat, at which point I informed the pet sitter that they do not get along and that they should not be booked together at the same time.
Okay. And then what happened?
My pet sitter, he said that he'd ensure it did not overlap with any of my cat's stays and that he would adjust the booking. This has included attachment C of my my attachments. I apologized to him for whatever happened, whatever Ryan said to him, because he did express that our issues had been communicated to him, and I have no idea what Ryan said. I preemptively apologized for it, explained briefly what was happening, and told him that Ryan's dog was sweet and well behaved, but he doesn't respond to cat boundaries and exhibits aggression. And I didn't think that it was a good idea for his dog to be boarded there, considering that Parker primarily boards cats.
All right. I see that now. What attachment C is now described better from my understanding.
I'd also like to state that I only ever gave Ryan Parker's first name and that he was on Rover. There's over 270 people on Rover within 30 miles of Ryan's address, and I have no idea what would possess him to go seek out a cat-oriented pet sitter to leave his aggressive dog at, other than to make a statement and make a threat.
A threat of what are you concerned with?
That his dog would attack my cat or
And
other
then-
cats in the home.
All right. So you have something from a Nathan Colton, September 6th. What am I to take from that?
This was a communication with the book club. This was just stating that I noticed Ryan had joined the book club, and I asked that he be removed as he'd never participated. And I thought that it was just to keep tabs on what was happening, because I'd asked him to stop contacting me.
Right. I'm just reviewing, see if I have any further questions before I turn to Mr. Carter. All right, Mr. Carter, your response to this request for an order, and I did have a chance to look at what you filed, and obviously we've talked about some of it. What would you like to say?
Yeah, so Your Honor, it is correct that I have left my lease. However, I have been in communication with the management where they had agreed.
Well, here, let me focus you in. What's being alleged is you're committing unlawful harassment against Ms. Hughes, and she wants an order. And she cites the book coming back, the book club, the boarding of your dog, that there are implied threats to her. Maybe you can answer some of that. You've filed a lot of information here that we've looked into partially, but what would you like to say about that claim?
Yeah, so the book, I was informed by PJ that I was borrowing it. So clearly
Who's
there's,
PJ?
sorry,
Miss
Miss
PJ?
Hughes. She also goes by
All right.
PJ.
All right.
When we had the conversation about the book, it was, and this was before a falling out of friendship back in probably August, when she had communicated that she was taking a step back from the friendship. I thought it was the right thing to return the book, and I had included a note saying, "Thank you for letting me borrow the book." I was not meaning any form of harassment or intimidation. I was really trying to do the right thing. When it came to the book club, I had been a member of the book club since at least July, if not sooner. We had talked extensively. Unfortunately, most of our communication was on WhatsApp, which I don't have the copies of. But we had talked extensively about the book that was chosen, and moving forward. And I was looking forward to participating in the book club, which was why I had RSVP'd. When I was drastically removed, I had tried to join the book club again, thinking it was a glitch. And I messaged the admin saying, like, "Hey, can you explain what's going on?" Which is that attachment, which has been discussed already, Exhibit 2 on mine, where all of my, so that first message one is from me. The second message is from Nathan. And it really was out of a place of concern. And, you know, if I was being inappropriate, I want to know so I can correct the behavior. And especially in my situation and being a member of the LGBT community, having safe spaces for me is incredibly important. The actions that PJ took removed a safe space for me that I was looking forward to participating in this book club, you know. And from the conversation with Nathan, I had specifically asked, am I no longer welcome at the Rainbow Center? Which he had informed, you know, it's not his decision and that he's just going to communicate with them. And my final message to him said, you know, I'll just avoid the Rainbow Center due to the conflict of this individual, because I don't want conflict with Miss Hughes.
Did you know the individual that he was talking about was Miss Hughes?
I had assumed so because of the conversation from my ex-girlfriend and current roommate had informed me that Miss Hughes had caused the removal.
All right. So when you say that this safe space was removed from your access, did you do anything to Ms. Hughes?
No.
Okay. So what about the boarding of the dog?
So the dog boarding, I had established that in August. And the screenshots that I included, and now I should have, you know, hindsight's 2020, I should have included those original screenshots from August. However, as soon as Parker, I thought that it would be fine. We could be professional adults and have a separation, because I was viewing it as a business. Miss Hughes had also not conveyed that my dog had been aggressive with her cat the day that she had boarded him. If I had known he had been aggressive with her cat, I would have chosen a random rover. But I was going off of her recommendation that he was a great rover and that he was close to the airport. And I value word of mouth recommendations. So as soon as Parker had canceled the booking, I went and found another booking that was closer. Due to this whole situation, I don't feel safe, and I'm in the process of moving to Wisconsin.
And so other things that you filed here, the screenshot, Exhibit 5 screenshot of last text message with PJ, who's I now know is Ms. Hughes. What am I to take from that?
That was just to establish the last communication via text message, was on August 4th. Additionally, the screenshot of the final Instagram message, just to show that I really I've gone out of my way to not contact her. And I've blocked her on all social media. Additionally, her friend and my ex-girlfriend.
So you've known each other, you agree, 4 to 5 months when all this began, so sometime for like April?
Yep.
All right. Anything else, Mr. Carter?
Yeah, so by Miss Hughes filing this, I've had to report to my work, and my security clearance is under investigation, which I have reasonably Miss Hughes understands and knows, as she is a Air Force veteran and had to go through similar processes. So my security clearance, my livelihood, is all in jeopardy due to this filing, potentially. And I strongly disagree with it. And I wish things had changed and ended better on better notes, but I don't want anything to do with Miss Hughes or my ex-girlfriend. And I have been going out of my way to remove myself and to be thousands of miles away from Miss Hughes and my former place of residence.
Reviewing to see if I have any further questions here. All right, so Ms. Hughes, Mr. Carter, I'm not issuing an order against Mr. Carter. I have to follow the law that defines what unlawful harassment is. Now, Ms. Hughes, you may feel harassed, but the definition under the law is very different. It just doesn't rise to that level. I can't issue orders against folks that you just don't want contact from, that you think are rude or obnoxious, but all of this that's been relayed in writing, and the exhibits and the response and what I've heard today, all of it, none of it amounts to what the law says is unlawful harassment that allows the court to issue any kind of order against Mr. Carter. And obviously, it's clear that you don't want any contact with Ms. Carter, and Mr. Carter seems to say the same at this stage. So I leave it to the two of you not to have contact with each other, but there just isn't any basis under the law to issue this order. So everything ends today. And so Ms. Hughes, Mr. Carter, you can be on your way, and that's the hearing for today. Mr. Goodman,
Thank you, Your Honor.
raise your right hand, the
Thank
other
you.
right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
All right. And Michelle Hoob, are you there?
Yeah, she's here. She's just sick.
Okay, we'll talk about that more. Michelle Hoob, can you raise your right hand with me? I can't see you. The camera needs to shift to your right. And we've lost him. Are you still there?
Yeah,
There you are. All right, Michelle Hoob, do you swear to tell the truth, the whole truth, and nothing but the truth?
yes,
Okay, Mr. Devaney, come back to you. Raise your right hand, Mr. Devaney. Swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, so Michelle Hoob, looks like you're pretty sick. Is that right?
Yeah.
Michelle
Yeah,
Hoob,
yeah.
I need to hear. All right. And so you think you got COVID?
yeah.
All
I
right.
just took a test this morning and it came back positive. I've been sick for like 4 days now. So
Okay, so I can't see you. I don't know. There you go. So keep it moving to the right so I can see Michelle Hoob. All right, so I'm divining that you don't feel up to this.
I mean, I'm fine with this. I just
Well, I'm expecting that you're able to defend against a request for a restraining order, and there's been a temporary one issued. And you're lying down on the couch looking pretty sick and saying you've been sick for 4 days. So I'm not going to force somebody who's lying on the couch sick to go forward with a hearing. I would grant you a continuance. The order would stay in effect, but we would have another court date when you're well. Make sense?
I'd rather just do this, get it over with, and not have to do.
Well, what if things don't go your way? Would you have said, maybe I could think more clearly and be more able to respond to this if I wasn't so sick? Yeah. So, and since the allegations here were revolving around Mr. Devaney, Michelle Hoob, all of it's pretty much the same. What I'm thinking, Mr. Goodman, is just that Michelle Hoob, I don't think, is in a position to respond to this. And the orders would stay in effect, but we would find another court date, and then it would have everybody well and able to appear. Mr. Goodman, make some sense?
Yes.
Okay, so Michelle Hoob, Mr. Devaney, I'm not going to separate these. It makes sense to hear them all the same. It's an efficient use of the court's time. So we're going to talk about another court date and looking at, pardon?
13th.
Okay, Mr. Goodman, it's a Monday morning, 13th or 20th?
Yeah, that's fine. 20th is fine.
Okay, 20th of November. Ms. Shalhoub, Mr. Devaney, 20th of November.
Okay, one thing I just wanted to mention is that
I just want to know if you're available November 20th.
Yeah.
Be available. Yes, Your Honor.
Okay, Thea? All right, so we're gonna be back November 20th, 9 o'clock. You can appear by Zoom just as long as we can see you and hear you well. My thought is that given that kind of time frame, you're gonna be much better and be able to deal with this. There's information in the court file that everyone may want to review. Let's see. Before that hearing, so I would suggest everybody should go to the court file and be ready to review things. No, nobody needs to serve anybody notice anymore. You're now served. We've got this hearing date, November 20th. And then Ms. Shell, Mr. Devaney, go to the court file and review all that's in there so that you're prepared to respond. And if there's anything you want to file that you think the court should look at before the hearing, please do that the week before so we're ready to go. All right.
All right. I only have one question, Your Honor.
Sure.
My daughters were there, so they're like witnesses to what happened. So how would I, have them say something in court? I'm not sure how to do that.
How old are they?
They were not there, Your Honor.
Well, how old are they, Mr. Devaney?
My oldest daughter is 18, and my middle daughter just turned 16.
Okay, well, you could have them available for the court to put them under oath and hear from them. That's usually the best way.
Okay. Would they just go on that day that I go in there, like on Zoom too?
Also you could have them write out a statement and you can get that filed with the court, but if it's not notarized under penalty of perjury, it's going to be hard for the court to review. So, but if you want to do it that way, it would need to be notarized under penalty of perjury, and then Mr. Goodman can review it once it's filed with the court, but nothing comes in after November 13, the Monday before. The court may not review whatever you file after that day. So You've got November 13.
My only question, revolving this issue, Calvin Goodman is my boyfriend. He's been missing for 6 days.
I'm having a hard time hearing you. I'm sorry. What did you ask?
Calvin Goodman, who is Frank's son, who this issue is regarding, his son has been missing for like 6 days. We're all really worried about him, so I don't know if
So not
Frank
taking up any facts or making any decisions other than continuing this hearing and keeping this order in effect. So if there's evidence that you want the court to consider before the hearing, then get it filed by November 13.
It doesn't have to do with that issue. It's just something that recently happened. So if Frank was aware of that, or maybe he knew where he was, it could not worry so much. I just hoping maybe.
All right, so we'll be back November 20th. If you have anything else, you file it by November 13th, and we'll see you both then.
Yep. Yes, I do, Your Honor.
Okay, good. All right, so Ms. Karen McCombs, are you still asking for this order against your daughter?
Yes.
All right, and Colleen McCombs, do you object to the court issuing such an order?
Absolutely.
Okay, so we know where we stand. I'll be looking left and right here because I'm looking at electronic documents on another screen. The file is electronic, and so I am listening, but I'm looking at what you're referring to and what's been filed. So let's see. And in this case, there's Ms. Karen McCombs' petition for this order, for the temporary order that was issued. And Karen McCombs, are you prepared to go forward today?
Yes.
Okay. You're not asking for a continuance for any reason?
No.
Okay, that red lighted object, I'm going to need you to be closer to that. Either you scoot yourself and pull that closer because we need to capture you on the recording, and you can pull it closer to you as well. So you're kind of soft spoken. So if you can pull it closer to you and make sure, get it right up close to you and you up close to that so we can get you on the recording. It doesn't amplify, but we capture and then your daughter will hear you. So Colleen McCombs, are you ready to go forward to answer this petition? You weren't served other than, you got something electronic. You got the petition electronically. So you're ready to respond?
Yeah, absolutely.
Pardon?
Absolutely.
Okay. Yeah. All right. There's just a little delay. And so, all right. So, I've had a chance. Oh, thank you. Okay. You want to just give me the packet for this one too? And then you don't have to worry about it anymore. It is bigger than I thought. Thank you. Whole thing, whole darn thing. All right, so I've had a chance to review Karen McComb's petition, and the most recent event being the October 14th event. And I'm going to turn first to Karen McCombs, then I'll turn to Colleen McCombs. But and then Karen McCombs, you refer to things that have happened 7 and 8 years ago. Now that's not real pertinent nor relevant, but I understand it flavors how you feel about October 14th. So what would you like to say about why you want this order against Colleen?
From 7 to 8 years ago, this has been going on continuously. Continuously.
Have you ever
I can't
received an
stop
order protecting you before today?
I tried once before. I thought it was the boyfriend that was creating the issue, and you denied me.
Right.
So broken windows and damaged goods and things taken. And I
why
don't
do
know
you,
what else to do.
Why do you say this is Colleen? Focus in on
Blatantly,
October 14th.
blatantly on that day.
Okay.
She was supposed to stay and help me to do things. And she, first thing in the morning, comes and says, "Whose toolbox is that outside?" I said, "It belongs to work." I took it off the truck that I had borrowed to make a dump run. And I'd forgotten to put it back on the truck to take it in. And she says, "Well, I've sold it and they're coming to pick it up right now."
Okay. And what happened to that toolbox?
It's still at my house. I went nuts. I told her, "Just get off my property, go away, get away from me." Why would you sell something? She knew that wasn't my toolbox. She knew where it came from.
And then when you told her to get off your property, what happened?
She said no.
Okay. And then what?
I kept yelling at her. I went nuts. I don't
Did
get
she ever
angry a
leave?
lot.
Did she ever leave?
Yes,
that
she
day?
did.
Okay. What did it take to get her to leave your property?
A lot of time and a lot of yelling. And for her, I guess, to get a ride somewhere.
Okay. So how much time did it take?
It was over an hour. It was well over an hour.
All right. So she needed to make a call, get a ride out of there. And you were just saying, leave my property. So before then, was she living with you or visiting?
No.
No.
She just drops by now and then.
Meaning drops by but doesn't stay over?
She came on Friday the 13th.
Okay.
And I asked her if she could help me this weekend because I work all week. I'm not there. And she said, sure. And she stayed over.
Okay. All right. And so was that kind of usual that she stays over to help you with things the next day?
Occasionally, yes.
Okay. And this is your house or a rental? Or
My
what?
house.
So you own the house, or you're paying on it? Okay.
Me in the bank.
Yeah, you in the bank. All right. And then you said you think it was your daughter several weeks prior to in this petition had a hot tub in a box. She wanted to sell it. Can you tell me what was going on there? Ms. McCombs, we look like we've lost your video. Are you there?
Yeah.
Okay. All right. So go ahead, Karen McCombs.
She told me I have somebody that wants that hot tub. And I said, no, it's not yours. Leave it.
And what happened?
When I went to work, I got a call at work from somebody saying, hey, is she supposed to be taking that hot tub? And I said, absolutely not. I'm going to call her. I called her. I said, do not take that hot tub.
We've lost Ms. McCombs again. Ms. McCombs. Colleen McCombs, you there?
Yeah, sorry.
So you having difficulty with your connection? What's going on?
Apparently, I'm not sure, but I'm. Can you hear me still?
I can hear you. I can see your forehead. So maybe you need to move the camera down a bit so we can see your face a little bit more.
I'm rather emotional about this.
Right, but I have to be able to see you, and I will hear from you. So we're going to soldier on here and see if we can't get through this hearing as long as you have a good connection. So back to you, Karen McCombs.
I called her and I said, don't take anything off my property. Stop taking things. Don't take stuff from my property. Do not take it. She said, okay, I won't.
All right.
I took her at her word.
Then what happened?
I don't even think it was an hour later. I got a call saying, She loaded it up in the back of a truck and took off with it.
We lost her again. I'm sorry, we can't go forward without Ms. McCombs with us.
I do have a statement from my sister. I didn't realize.
Slow down. I can't take any testimony.
Oh,
unless
I'm
we've got
sorry.
Ms. McCombs. Ms. McCombs, are you there?
That,
All
yeah.
right. Okay, so we're talking about the hot tub a couple of weeks before October 14th when this order was issued. And I've heard from Karen McCombs that she told Colleen McCombs not to sell it. And then Karen McCombs, was it sold?
I have no idea. She just took it.
So it's gone from your
Just like
property.
everything else, yes.
Okay, so you don't exactly know, but it's gone against your wishes. All right.
I didn't
and,
get any money for it.
And then, let's see, also talk, let's see. And then you go back 7 years. Was there anything more recent than 7 years other than the hot tub issue and the toolbox issue that we've been talking about?
So many things that I can't even, I have no dates to put to them. I go to work and she'll take whatever she wants. I've changed the locks in my house countless times. I don't know what else to do.
When did you last, you think, change the locks?
I think it was 5 or 6 months ago.
Okay, so we're in November almost, so sometime in the summer?
Yeah.
Okay, so like June, maybe May. Okay. And why did you change the locks?
Because she kept coming in and taking things. She'd take my groceries. She would take whatever.
Mm-hmm.
She just decides that she's entitled to it for whatever reason. This is the hardest thing I've ever had to do because this is my daughter. I raised this child. She was not raised to be disrespectful and just do whatever she wants to do. She hasn't had a job in I don't know how long,
So
but she sure was
focus in
entitled to that
here.
unemployment, huh?
Well, let's focus in here. You're alleging unlawful harassment, but what you're saying here is stealing. And that she's
It's
coming into your home without
bullying
your
too.
into your home without permission. Is that what you said?
Yeah, she just comes over whenever.
We've lost Ms. McCombs again. I think we're not going to be able to get through this hearing today. Ms. McCombs, Colleen McCombs, are you there? Yeah,
Yeah.
we can't get through this hearing. You don't have a good connection. I can't get there.
I apologize.
So I'm going to have to reset this hearing, and Ms. Colleen McCombs, you can come into court. Zoom is an alternative and it has to work. We have to be able to see you. We have to be able to hear you reliably. And it's not your fault if the connection isn't good, but you'll come to court then if you can't solve this at a better place, a closer place, something that has a better connection because we keep losing you. The order is going to stay in effect until that hearing day. But Ms. McCombs, if you can't find a reliable connection, then come into court. Zoom's an alternative. Court is the primary way of appearing. All right. So what that means is we're going to talk about a court date, 13th or 20th. Either one.
At this point, they're getting full. How
about the 20th? November 20th is Karen McCombs, the 20th. And Colleen McCombs, November 20th.
Yeah.
All right, so I'm going to reset. Nobody has to serve anybody notice. Everybody knows that court date. And we'll be back and we will make sure that we've got a good connection.